Okay, we're good. I'll call the meeting to order here. It's 5 o'clock. Start with the adoption of the agenda. Anything else from administration?
I believe there was a closed session that was requested.
Okay, and then from council, a closed session.
Yes, please. I'd like to request that a closed session be added to the agenda pursuant to section 197 sub 2 of the Municipal Government Act and section 17, 19, 23, and 24 of the Alberta Information Act, as the matters to be discussed involve personnel, information, labor, and employment matters and contractual discussions related to the CAO contract and salary comparable.
Make that 7.6, I guess. Anything else from council? I can get a motion to accept the amended agenda. Councilor McNeil,
I'm prepared to motion that we accept the agenda as amended.
the councillor, call the question, all in favor? So moved. Adoption of the agenda, October 15th, 2025. Comments, questions? See any? If I get a motion to move the minutes? Councilor Dean?
I'll move that the GMP committee minutes of October 15th, 2025 be adopted as presented.
Okay, speaking to the motion?
Mr. Eve, if we could before the motion, there's a carried missing on, I believe, 8.1 of the minutes.
Yes.
So if Councillor Dean would accept a friendly amendment to adopt the minutes as amended.
Absolutely.
Okay, amended motion on the floor. Any other discussion to the motion? Not seeing any, I'll call the question. All in favor? It's moved. Sound command, or 7.1, bylaw 634/25, community standards bylaw.
If we could allow Mr. Raposa there to speak to this item, would be really appreciated.
Good evening, Mr. Raposa.
Good evening. So what we have before you today is administration is seeking to amend our community standards bylaw. Currently, we have 2 active community standards bylaw, and with the land use bylaw being updated and a few other issues that administration has been encountering over the past couple of years, we're looking at making a few changes to it. Recognizing that this hasn't been brought forward for discussion yet, that's why we're bringing it forward today, is to hopefully facilitate some of that discussion and get some direction on the required outcomes of the bylaw. That being said, I would like to highlight some background information on why we're seeking updating the bylaw, and then go into some of the amendments that we're proposing in the attachment in front of you today. There are 4 attachments attached to the RFP. The first one is I've included a version of the bylaw that's highlighted all the additions for ease of reference. I've also included the draft of the community standards bylaw under 634/25, and then there is a copy of the 2 existing bylaws for your reference. Okay, I'll get right into the big ticket items then. So over the past year and a half, one of the major issues that we've encountered with the community standards bylaw is currently during operational maintenance throughout the municipality. We've ran into issues with vegetation overgrowth from private properties onto county property. And right now, there's really no mechanism in the current bylaw to address this issue. No way of having a formalized process to notify people to remove vegetation if it is an issue, and no way to make people to remove it. Another issue that has come up is extension cords being left on county property that's interfering with snow removal and maintenance. So what we're proposing in this new draft is adding clauses into the bylaw that would effectively address this, that would allow for county staff to notify individuals to remove vegetation, remove extension cords. And there's also a mechanism in there that if they don't remove it, that the county can remove it and charge the prospective landowner for those costs. Another change that we're looking at making is a housekeeping update with the new adoption of the land use bylaw in September. The community standards bylaw, the current version, has a lot of definitions that were based off of land uses in the old land use bylaw that no longer exist. So to provide some clarity and remove some contradictions, we're looking at removing all the old definitions and instead replacing it with language that if you have a permit under the land use bylaw, that the permit conditions prevail over this bylaw. The next would be the expansion of applicability. The current bylaw only applies to residential parcels. And what we're proposing is that it expands to all privately owned parcels. Reason being is that we've received multiple complaints of individuals that are affected by debris, garbage, derelict vehicles on commercial industrial lots that aren't a part of an approved use or approved permit, that we don't really have a mechanism to do anything about. So we're looking at expanding that so that if there is, you know, a justifiable reason on why action should be taken, that we do have a mechanism to clean those properties up. So we've changed some clauses for that. The other thing is that, major event permit thresholds. Right now, the threshold is 250 people. So the bylaw, right now we issue event permits. And event permits are essentially a way of the county having some level of oversight over events going on in the county. The reason being is that there's traffic considerations, emergency considerations, and so on that we need to ensure that we're protecting ourselves, but also the people attending those events. So we do have these event permits in place. That being said, they currently only apply to events that have over 250 people. In the last year and a half, in my time here, I have not seen an event with that many people. Most events that we get inquiries about are around the 50-person mark. So what we're looking at doing is aligning that number, reducing what would require an event permit from 250 to 50 people to align with the events that we're actually receiving in the county. So we could still have, you know, some level of oversight so that we could take into some of those considerations, because the considerations of an event, whether it's 50 people or 250, doesn't really change. Right now, we have no way of addressing that. So that's some of the big button topics, but really why we're bringing this forward today is to get some feedback and direction on how we want to proceed with the bylaw. The first consideration is we're seeking approval of the overall direction, so including the stronger enforcement tools, consolidation of existing bylaws, and the provisions addressing vegetation extension cords and non-residential parcel impacts. The next would be that the committee consider, we're asking the committee to consider the proposed expansion of applicability of the bylaw to all privately owned parcels. Third one being that the reduction in what would require a major event permit from 250 to 50 people. And we're also seeking direction on what level of public engagement, what public engagement expectations would be, committee guidance on what kind of broad community engagement they'd like to see, targeted hamlet-based engagement, issue-specific outreach, or just an overall engagement throughout the entire county. And finally, administration is seeking committee direction on the process of sequencing, including whether the draft should undergo legal review before returning it for further consideration. And we're also looking at the committee wishes to see a revised draft following engagement or prefers the next version go directly to council. Following committee's discussion, administration will revise the draft bylaw based on the guidance provided today, develop appropriate engagement materials if directed, obtain legal review if required, and depending on the committee's direction. The goal is to ensure an updated community standards bylaw is clear, enforceable, and reflects community expectations. That being said, there's also one more point in this RFD, is that the bylaw currently is silent to agricultural parcels. Throughout the bylaw, a lot of the provisions exempt agricultural operations, and we've left it that way in the draft. That being said, there are a handful of agricultural operations that we see storage of materials that we would not consider agricultural use, whether that's disposal of old vehicles and so on. Right now, someone can make the argument that it's for agricultural purposes, it is kind of exempt. There are some other considerations in the land use bylaw that we can enforce under, but we've kept it silent in this. We've just kept it as is under the current version. We haven't changed it. So right now the provisions are exempt any agricultural pursuits. So that being said, I will leave it on the floor for discussion, questions if you have any.
Thank you, Mr. Reposa. Open up to the floor, councillors. Councillor McNeil.
Sure. Through the chair to Mr. Reposa, first, I'd like to say thank you for the way you presented this and highlighting it the way you did. I thought it made it incredibly easy to go through and read. And I'll apologize because I have a number of comments, but I didn't have time to summarize them. So
Okay.
as going through, my first concern is creating a level of law that's difficult to enforce. So when we're talking about making, moving the number from 250 to 50, personally, that knocks out birthday parties, anniversaries. Like, I think it's actually quite common in our rural areas to have 50 people come to our house for different things. So I would like to see that threshold likely lifted to 100, because where 50 people is 10 cars. You know, and 10 cars going into a residential rural property isn't like 10 cars going into a town property and 50 people being, you know, on a small lot in town. So I can kind of see some of those areas might be different. Also, the next one was about under the permitting process. So whether it's whatever the threshold is, just that I think the permitting process for it should be really easy, whatever that looks like, so we can remove as much friction from the permitting process so that people won't be opposed to doing it when they actually are having these events. And then once legal approves, my opinion was that straight to council unless engagement or legal identifies notable issues. So then just moving into the actual document, bear with me. Okay, so with the major event, when it talked about 50 tickets or paid admission, or 50 people or more, so can be accommodated if there is no admission. So what I was looking for is in here, was there something that would make a birthday party, for example, exempt, but it doesn't appear to be that way. So I think there could be unintended consequences for family gatherings. My apologies, they're just noted in the document here. Section 4.15, in my package, it's page 17 of 156. Bullet B, delivered through electronic means, including but now limited to email. I'm guessing it should be included but not limited.
That's correct. That's a error that I can fix.
No worries. And then just on section 5 on the very next page, 5.2 section B, it talks about the county may at sole discretion remove any encroaching overgrowth. Bill the owner or occupier. Should this take place, the county will provide the affected property owner or occupier with 72 hours written notice before taking any action to remove the overgrowth. I was just concerned, especially where a lot of overgrowth happens in the summertime, that is 72 hours a reasonable enough time for vacations? Would 7 or 14 days be more realistic? Okay. Then, under the vehicles, part 6, section 6.1, where we talk about no person, owner, or occupant of a property within Woodlands County shall have more than 2 unregistered or inoperative motor vehicles. I guess my question, again, looking at rural areas, if this is reasonable, I don't think registration is necessarily the concern. I appreciate the concern likely is unsightly, and how would that be defined? How would this be enforced? And I expect there's dozens of properties across the municipality that have more than 2 inoperable vehicles. So do we have a mechanism or an appetite to fund bringing those properties into compliance? And if we don't, then I'd ask council if we want to consider not having that in there. And then my question through to Mr. Raposo is, can you please verify, I believe in the land use bylaw, there is unsightly premises already in that bylaw. Is that correct?
Yeah, that's correct. It doesn't go to the extent of what's currently in the community standards bylaw, but it is there. So if there is any unsightly uses that aren't approved, there is a mechanism to currently enforce it in there. That being said, this kind of expands on that a little bit, so.
Okay, thank you. And under section 7.1, so this was no regulating noise. No person, owner, or occupant shall make or continue to make, cause, or allow to be made any loud, so it's the allow to be made that I had noted. And I guess I'm thinking on that, if you could give examples in the context here, or if there's something so that people can understand the applicability. And I know different times there's been discussions about barking dogs, and you know, I think one of our bylaw enforcement officers had mentioned that it's very difficult to enforce something with a barking dog because they had to have video of that dog actually barking, etc. So if we're putting in here the onus on the landowner or occupant to control the noise within the confines of their own property, is there a way that we can maybe beef this up a little bit to make that be for any noise? Whether it's a barking dog or a, you know, a loud anything. So I guess would kind of be my question.
Yeah, absolutely. Through the chair, yeah, absolutely, there is. The intent of the clause was to be pretty general for that purpose, so that it could encompass many different issues. That being said, if there is something that you'd like to see put in there that would you think would further strengthen that clause, that's definitely something we can do. Right now, the intent of the allowed to be made is really to address dogs. We do have a dog bylaw, so that is covered to some extent in the dog bylaw. The other thing is that if you have other people that say come to your property and they're causing noise issues, that it's your responsibility as the owner to make sure that they're not causing a nuisance for the neighbors. That was the intent of that wording, but it can for sure be changed if needed.
Okay, and then under section 7.4, if a motor vehicle is the cause of any sound that contravenes a provision of this bylaw, the registered owner of that motor vehicle is liable for the contravention. So I'd recommend removing or changing because it adds an additional layer for enforcement. The noise violation in general should be the responsibility of the landowner or the occupant, because that would be my caution, is that if we have an officer sent to that area for a land complaint, and then we added now complexity that he's looking for the registered owner who may be in Timbuktu kind of thing, so just to simplify the process. And only a couple more, guys, sorry. 7.12, section D. The provisions contained in this part, so we're still talking about noise. And under D, it says the use of signaling devices on vehicles in the normal operation for the purpose of giving warnings to other vehicles or persons. So I flagged this one particularly, it was something I had intended to bring to council in the new year, was about how can we look at backup alarms and reducing some of the noise encroaching on other properties. So for this one, I have, for example, I'd like to see this expanded to account for things like backup alarms used on equipment in nighttime hours adjacent to residential areas. So broadband reverse alarms would be recommended in these areas. And these broadband reverse alarms are an add-on that's could potentially be $150. And I don't know that this is necessarily the place for it, but instead of creating a whole separate issue around that, I think it's a potential that we could look at options like that for inclusion here. Okay, and,
I'll hold you for a second,
Oh,
Mr.
sorry.
Reposa.
yeah,
Mr. Chair, if I may, just for clarity, so I just wanna make sure I'm capturing that point. You would like to see those exempt, or would you like to see those?
oh, sorry, the broadband ones used in areas that are adjacent to residential. Sorry, I didn't,
And those would be exempt, or do you want them to be
Oh,
included
we
in the
would want them to
exemption
be-
clause? Or do you want them for us to be able to enforce to say, don't make that noise?
yeah, and good question, thank you. I guess basically the intent would be is that we don't want the noise encroaching into the residential area, and a solution for that could be the broadband. So maybe they don't even need to be referenced here, it would just be if there was an enforcement issue potentially, that the solution could be offered as the broadband. So,
If I can, through to administration, maybe CEO Ferris can answer this one, but especially we're talking commercial equipment or stuff around the airport area where is an industrial park and people have backup alarms, can the municipality legally tell them what type of alarms they can or cannot have on their equipment or their vehicles?
Through the chair, my recommendation, if you're going to do that, would be through development permit conditions, rather than this mechanism. So it's possible for us to regulate. I wouldn't recommend that it occurs through this bylaw.
You got another point there, you said?
yeah, you bet. And thank you, that sounds like a great spot to put it, actually. Okay, so then under section 7.15, item I. So this is when we're back talking about the events and permits that must be made at least 60 days prior to the proposed event, and the requirement of having liability insurance. So again, I'd bring up a birthday party. I don't think it's reasonable to ask our residents to have liability insurance for dad's 50th birthday or something. So, okay. And I do believe there is just one more on page 24. Under the specified penalties, right at the end where we go to 7.18, the failure to obtain a major event permit. Again, just kind of flexing on the birthday party thing. I think this could vary. If it's a ticketed event that they intentionally operated outside of the law, I think that's one type of infraction. But if it's something that, a wedding or a party that somebody really didn't understand what the law was, and didn't know they needed a permit for, then I don't know that it's reasonable to bill them $500 for a first offense. So was kind of my comment on that one. And then the next one under 9.1.
This last one, and then I'm gonna move on because we have other people here still.
Yep, you bet. This last one is under 9.1. The registered owner of vehicle responsible for dumping. So currently this is at $500. I would like to see, with the problems we've had with dumping in our municipality, I'd like to see this set at $2,500 or possibly $5,000. So, thank you, and that was all my comments.
Councillor St. Martin?
Mine are, Mr. Reeves through to CAO Ferris. Can you clarify the major events permit? Is this intended to be on public lands or private lands or both?
Through the chair, my interpretation is both.
And, Mr. Chair, through to CAO Ferris. So previous to this draft bylaw, we have regulated events on private property.
I'd probably rely on Ms. Ludwig.
Through the chair and CAO Ferris, yes, we have. We have a event that occurs up in the Fort Assiniboine area, and it takes place on private and public property. A portion of it is where there's actual campsite, and over 500 to 1,000 people attend that particular event. So they have a camping permit on the private side of it, and then the running event itself does take place on public lands. And we've also in the past had a application for a concert on private lands. That was up in the Blue Ridge area several years ago, in which we heard loud and clear that neighboring residents did not want, and it did not occur.
Thank you for that clarification. With regards to consolidating, I have no concern with that. However, I do have concerns with expanding it into agricultural properties. And just a couple points there, you know, agricultural properties typically tend to be generational or legacy, and a lot of these vehicles might be generational or legacy type vehicles. And it's certainly not something I'd like to see in the agricultural district. I'll leave it at that for now, thank you.
I got a couple questions, and through administration, now when we're talking, obviously setting this up, when we talk about major events, I would like to see more, we'll see definition between what's considered a major event or a private event. You like, whether again ticketed or, you know, more structured events, I could see as being more of a major event, but again, birthday parties, weddings, stuff like that, they're a lot more of a private event. If somebody's doing something in their own property or that end, I don't think we're gonna get a lot of buy-in from the public even coming and doing, you know, if we put this in here, somebody's having a wedding of 100 people in their property, especially then again, I don't even think we're gonna hear about it. So I don't see the point in putting stuff in here that unfortunately is not gonna be utilized. Next, you know, I wanna talk about the backup alarms. I understand, you know, the noise and stuff to them, but when it comes to backup, there's a lot of newer vehicles that are small automotive vehicles that come factory with backup alarms also. So if we're gonna start trying to restrict what type of backup alarms we have in one district, but we have vehicles that come from factory as a small car with a backup alarm, I don't see how you can regulate one but not the other. I understand, you know, noise, I understand it's a lot, but even, you know, outside of commercial or whatever, the districts next to residential, you could have people with their work trucks. I know a lot of forestry vehicles, a lot of oil and gas. It is a company policy to have a backup alarm on their vehicle, and you're gonna see these in residential areas, and trying to restrict noise from a backup alarm. Again, I don't feel that there's much we're gonna realistically be able to do there. And I know we understand that the cost, say, well, it might be $150 per unit, but if you have a large fleet or numerous vehicles or a company and saying you have to run this type of alarm in your system, it is a bottom line change. And those, you know, country that we're in, a lot of those units underneath vehicles, they rot off, they break, and they end up going through numerous ones within a year. So yes, there's an initial cost, but those costs can be multitudes throughout the year per unit. So I don't feel that's something that we should be, you know, looking at to a reason. I mean, if you have 30 vehicles sitting in a parking lot next to a house and they all in reverse just sitting there, I get it, but for the odd vehicle or equipment moving around, I think, you know, part of living in the country, you're living next to some of these developments that you buy or they're there, it just kind of goes with it. And when it comes to the extension cords, now this is gonna be something I understand that it is a tripping hazard. We have talked about the damage it can do to some of, if they're not off there and we hook them with our blades or the snow blowers running through the hamlets. Procedurally, if we are going to, like, again, winter, people gotta plug in their vehicles, they don't, a lot of them aren't gonna start, especially in the cold. Is there gonna be notice to the public ahead of time that we're coming through to remove snow? So they have the opportunity to move their cords or get them off, so that, I guess, ahead of time before us just showing up and saying there's an issue.
So through to Reeve, in the notice provisions, that can definitely be added. That could be a very simple addition to ensure that we're notifying people. Understanding that, that is something that we deal with in the county. I have no problem adding a clause in there just to specify that we're notifying people beforehand.
No, and even something similar to what the town does with just a sawhorse and a sign saying that we're coming through to make sure that things are off. It's fairly inexpensive and they're not large hamlets, people will see them. I was gonna say, Mrs. Ludwig,
Through the CAO to Reeve, just with respect to one of your comments in regards to events on private lands. I understand that aspect of it. However, we get several requests with respect to our recreational sites to host various weddings, birthday parties, etc. And I think maybe that was part of the intent of the events, maybe on a smaller scale. I mean, I understand that it's difficult to control on private property who's coming and going. However, I know we do get several requests a year, particularly in the summer months, for weddings on a few of our properties. One in particular on Old Ferry Loop. We've got a parcel of land there that it's highly desired, even just for photography, but we have had events held there, as well as I know that our Hard Luck Canyon, there's several weddings occur down there too. So just wanting, I guess, clarification from our perspective, would it still be something we'd want to do on our own county-owned lands, is to obtain those event permits?
I agree, in county-owned land is a little bit different than somebody's backyard, but just as long as we have definition as to determining or distinguishing what, if we're gonna put something in a document, I just want to be something that is, has teeth or is fruitful or something that is actually usable instead of just in there for the sake of having it in there. Mr. Ferris?
Just a couple things to council. Just hearing the discussions that have occurred tonight, I think probably a best practice, this draft bylaw builds upon our historical practices with special events. It is not uncommon in Alberta for a municipality to have a special event bylaw standalone to itself. That could not only better flush out the procedural questions that we're hearing, but also include a better definition of exemptions, what triggers it, the process. If we're receiving formal application processes, the public has an ability to formally appeal a permit process. And if those are all valid comments that I've heard from council, the best option would be to probably remove the special event stuff entirely from the community standards bylaw, direct us to come back with a special events bylaw. That way we don't get lost with those concerns. And then supplementally to that, in regards to the alarms and the concerns that way, a mechanism to recognize that it's industry standard, it's best practice to have those alarms, that sort of thing. An alternative would be to set up a definition on daytime hours, particularly within residential areas, and have a list of those activities, whether it be using heavy equipment, snow blowers, leaf blowers, whatever, where outside of those hours, it's prohibited. In all reality, good neighbor principles should apply, but and with that, someone probably shouldn't be using their loader with the alarms at 11:30 at night or 2 in the morning. But that said, especially not in a residential area. Farming properties, commercial, industrial, those are different because they have permits, they probably have hours of operations. And so that middle ground to address it from council is probably better addressed if we were to put in a daytime operating hours with a list of exclusions that cannot occur outside of that. And as a middle ground for the comments that I've heard so far.
Thank you. Anything else from council on this? Councillor Kuchen?
Yes, through the chair to Josh. In on 5.5, accumulation of materials, one of the things that's become very apparent with the use of ag plastics is it ends up sometimes half a township over from where it was actually. So I think, I don't see it included in here, but I think that maybe a definition would be in order there.
Through the chair, we do have a definition on what constitutes nuisance in terms of materials. I'm just trying to find that here, because I can see maybe it might be covered in there, and I just wanna confirm. What I can do is I can make sure that that is included in there.
Thank you.
Any further, Councillor Kuchen?
No, that's it.
You got Councillor McNeil and Councillor St. Martin.
Through the chair to council administration, I just wanted to clarify on the discussion about the sound when I brought up that backup alarm, specifically the context to what I was referring. Number one, I do believe we already have the nighttime hours and daytime hours defined in bylaw, and it does give examples and states. So I really like what CEO Ferris had mentioned, maybe potentially in the future, taking that consideration into a development permit, because what it's talking about isn't the one-off, somebody getting something delivered or somebody bringing their truck home from work. It's basically between 11 p.m. and 7 a.m. when you have a commercial facility or an industrial facility that has noise that will travel to a residential facility, that it is a retrofit that can make things easier. So it's definitely falls under good neighbor practice. I agree with the criticism that we don't want to be dictating to companies what they're using, but for a future consideration and conversation, if it's something tied to a development permit, it is reasonable that the expectation, the same as we talk about light distribution and light pollution leaving a property, sound is reasonable for leaving a property as well. And it's just that decibel level of noise. And this type of an alarm is something that's widely used in cities and other areas on this type of equipment. So it's not something that's new. So just wanted to add that clarification.
Councillor St. Martin?
Mr. Chair, through to CAO Ferris, I didn't read this here, but it might be in here if you can confirm. If a special event is using a provincial highway, they're required to get a provincial permit, are they not?
Yes, so anything within there would require a roadside development permit from Alberta Transportation.
Thank you.
And just one more that I have to administration and kind of echoing what Councillor McNeil said earlier about the 2 vehicles on a lot. I know especially some areas where you have, I have a neighbor who has multi-generational individuals living in one house. There is more than 2 vehicles that are registered there, and again, they're it's just the people, the number of individuals in the household. I think restricting, there's obviously a mechanism there has to be, because we also have individuals where it looks like a landfill with the number of vehicles that they have and, unsightly. But if you have properties where they have multiple vehicles, which fair enough, and they're out of the sight and they're behind the back, I don't think it's an issue for neighbors as much as ones that, if you're driving down the road and it's just right there in front center, or if you know that you have a place that again has multiple registered vehicles, but everything is kept and it's just the nature of the household and the people that are there. I think I think limiting it to 2 vehicles is a little much, but trying to find a way to make it where it's more around, I guess, where things are or the sightliness.
If I may, I do have one question through the chair. Would it be better suited if I changed the wording to derelict vehicles that are light? Cause I do understand, you know, there's a very big difference between an unoperable vehicle and a vehicle that is completely torn apart. That being said, definitely expand the number, or if we wanna remove it altogether, I wouldn't recommend removing it altogether. Cause then if we run into the situation where it does pose an issue for neighbors, we can't really do anything about it. Maybe, and that's a discussion, today we could determine what is the suitable number of vehicles that we're going to allow. And if we don't wanna do it, you know, restrict by number, we could put screening requirements for vehicles. That being said, if, I'm not entirely sure how it's gonna be formulated in the bylaw yet, but it's definitely something we can do. We can, play with that idea.
I think Mr. CEO or Ferris has a
Yeah, just
clarification.
through to council on that, I think Josh has highlighted it. Like the land use bylaw, this bylaw is literally directing how people use their land. Well, you're entitled to provide us some recommendations on vehicle numbers, that sort of thing. I would strongly recommend to council that you direct us to do some level of engagement with the public to get that number rather than to come up with the number yourselves. I'm sure your number would represent what your constituents would like, but I do think giving an opportunity to the public to discuss multiple sections in this bylaw is probably in everyone's best interest to ensure that the community standards actually reflect what the community wants, not just what we're recommending as best practice.
We'll take the last two here and we'll, Councillor St. Martin and Councillor Coogan.
Reeve Kush through to CAO Ferris. I really see a difference here between areas where you have a concentration of population. I can see some of these issues being bigger issues in that concentration, less than in the larger parcels, agricultural areas. So I think there needs to be almost two levels in what that is. I don't know. I definitely think this bylaw should come back after some of the edits have been made, before we go out for public consultation. And I definitely would support a review by legal.
Councillor Coogan?
Yeah, through the chair to CEO Ferris and Josh. For me, I'm having a bit of a difficulty here because we have a property that is right along 661 that is definitely, I don't know whether you would define it as an agricultural property, I think it's 80 acres. But it has probably 250 derelict vehicles piled up in no real order. So how would that be handled? That for me is part of the dilemma we're talking about here.
Mr. Ferris?
If I can through the chair, quite honestly, it wouldn't. That's why, as Josh indicated, the discussion is, do you want to have that legislation to flush out is a 250 vehicle storage yard an agricultural practice? Unless they're growing cars, I would argue it's not. And as such, there are properties like that that get away with the agricultural umbrella because of their size. Where do you want to address it? And I think the important thing there to consider is currently our CPO services are contracted. So we have an X number of hours a week that we utilize. But also no different than if you're driving on the highway, an officer has a decision to use their discretion on whether they pull you over if you're a kilometer over the speed limit or not, or even at 20 kilometers over. So there is a level of officer discretion and common sense that can also be fleshed out further policy-wise or procedure-wise. But by no means would we want to go after valid agricultural operations, and just because you have a bunch of pieces of equipment that are derelict so you can part them out for your other parts, perfectly valid farming operation. 250 pieces of vehicles to me is not, and that's the main reason for that discussion of, do we wanna open it up? So some agricultural properties that fall under that mechanism can actually be cleaned up should we desire it.
So I believe we have a bunch of recommendations and edits for administration. If anybody is willing to make a motion to bring this back with edits for further review. Councillor Dean?
So I see in the three options that were presented, option one looks like what I'm hearing council wants, with the exception that a legal review is not included in that. So if we could add a legal review, I could move that the GMP committee direct administration to revise the draft community standards bylaw 634/25 based on committee feedback and return with an updated version for further review after a legal opinion has been reached.
Thank you. Discussion to the motion? Not seeing any, I'll call the question. All in favor? That's moved. 7.2, review and simplification of procedural bylaw 625/25.
Just as part of the high level discussions that we had with Mr. Cuff here with the town, the procedure bylaw is here for two reasons. One, at our organizational meeting, we changed when we meet the Thursday, so there is that issue. The other aspect of it is a procedure bylaw that directs council how we wanna proceed with our agendas and our layouts of council agendas and various other aspects of council life. We just wanna make sure that it represents the issues that are the desires of council, and if there are changes, we figure this is the first GMP since the election. If there are amendments, there are changes you want beyond just the clerical housekeeping stuff that we need to address, we appreciate that feedback so we can bring you back a new bylaw that reflects your desires as council procedurally.
Thank you, Mr. Ferris. Discussion from council? Councillor Dean?
Through the chair to administration, so within this bylaw, would we deal with a committee of the whole item being placed on every agenda? Is that where this would
Through the chair, if council chooses that, ultimately, this lays out our agenda, the process of our meetings, that sort of thing. And we just wanna make sure it represents the desires of council. It wasn't that there was a significant amount of changes or administratively we're running into any issues. There is some housekeeping now with the changing of meeting dates, but beyond that, it can incorporate the committee of the whole discussion if you so choose, but ultimately it's discretion of council.
Councillor St. Martin?
Thank you, Mr. Reeve, through to CAO Ferris. So definitely there's some formatting and things like that. References to freedom of information and protection of privacy will have to be updated. I believe there was some changes that may need to be incorporated in here with respect to, I think it's Bill 50. So those will definitely have to be added. Thank you.
Anything else from council? Councillor McNeil?
I just had a question in regards to the procedure, and maybe this is answered somewhere else. When we're doing closed meetings and we're doing them over Teams and the video, do we have, what assurance do we have that the person that we're communicating with via Teams is alone in the room, or is that something that should be addressed in the procedural video? And maybe it's addressed somewhere else, I just haven't had that conversation since I've been on council.
Mr. Ferris?
What I can speak to is previous legal opinions wearing previous CIO hats and director hats elsewhere, was the advice that I had been given was it is the responsibility of the person electronically to make sure that they are in a safe position where that information cannot be disclosed, and it is the responsibility of the chair to confirm that they're in a appropriate location to have those closed session items. But beyond that, it becomes problematic to regulate that because as a counselor, you're entitled to the same information as everyone else. And then it becomes a perception that, hey, you're not included in that closed session because you should be, but because of your situation, it's limited. So the advice that I've received from legal in the past is it's the chair confirms, and then it's up to the responsibility of the person that is elsewhere to make sure it is confidential.
Councillor McNeil?
Just as a redirect, then if we're talking about setting the agenda, can we have it added to the agenda under the closed session portion? Just as a reminder that whether it's, the Reeve or chair in all our committees, basically, just that we should be asking that question, and then we have the question and we have the verification in case anybody ever comes back on us and says, well, I didn't know and we didn't ask.
Councillor St. Martin?
Just one more short, through the Reeve to CEO Ferris. I believe it's a best practice that when you come out of closed session, you actually have a period of time to allow the public to return to the meeting. And I don't think that's in here, so that might be something that you wanna add. And I guess my next question through the Reeve Council is, do we need to have like a standing closed session on the agenda? So in this procedural bylaw, we'll put that in there, and then it's a standard going forward.
Red nods here. Okay, looks like that'll be a standing item.
Through the chair, page 15 of the bylaw, clause 123, business of council intended to be dealt with shall be stated in the agenda in the following order. Items 1 through 13, number 12 is closed session.
Anything else from council? Councillor McNeil?
Bear with me just quickly, I wanna get to that page, but I did have a comment about the order, and sorry, through to the CAO, what page did you say the order of the
Sorry, it's-
agenda was on?
Page 14 of the bylaw itself.
Okay. Bear with me just 1 second here, please. Apologies. Page 12. Cause I think part of the concern was with the order, and if we have to cancel, have a meeting go short, that with the order of business, currently we have, that's what it was, administrative and departmental items are currently number 11. And I think we should move this up in the meeting to be more cognizant of staff time and put it immediately after delegations. Because what I'm seeing a lot of the time is that if we have staff here to make these presentations, that they're sitting through a lot of our meeting that they probably wouldn't really have to sit through. So if we could prioritize their time and get those first, and then we can deal with the rest of our business and free up their time.
Councillor St. Martin?
Thank you, Mr. Reeve, through to CAO Ferris. I understand your report item number 12 is closed session, but I think we need something under that it's a standing, the double and closed session, so that it would have the access to information in there, so that we have that opportunity at every regular council meeting. Thank you.
Councillor McNeil?
I did have another comment on page 18 of the bylaw. It's number 155, subsection 3. It talks about debate of motions and a motion to table. So for this context, table should be defined as the definition is opposite whether you're in the US or whether you're in the Commonwealth. So I think just to specify exactly what they're talking about. And then right below that in section 156, it's missing the end of the sentence.
Anything else from council? Not seeing any. There are two, I guess, motion items here. The first one is for, I guess, related to the Thursday scheduled meeting. The second one, I guess, would be to bring back the procedural bylaw as amended to council. Okay, so we have two motions. If somebody wants to make the first one. See any? I'll make the motion then, that council updates, or sorry, or is this all under one, do you want this under one motion or two motions? I just see number 1 and 2.
Sorry, the reason there was two potentials was I wasn't quite sure what structural or formatting changes council would want. I would be happy if the motion read that the GMP committee directs administration to prepare a revised procedural bylaw that incorporates the changes as discussed, and we'll go through all the ones that we've noted.
And that'll encompass the date change as well.
That will, yes.
Okay, if somebody wants to make that motion then? Councilor McNeil?
Okay, I'm prepared to make the motion that the Governance and Priorities Committee direct administration to prepare a revised procedure bylaw 62525 that incorporates the amendments and the discussion to be brought back to a future GMP meeting.
Thank you, council. Discussion to the motion? Not seeing any, I'll call the question. All in favor? So carried. 7.3 policy IS.I 6.402 fleet life cycle management policy and supporting procedure.
Just if I may, Reeve, Krish, following up on the comment of being cognizant for people's time, we do have a guest here, our assessor, and I'd prefer not, I don't know if we're paying him hourly, but I'd prefer not to have to pay him hourly.
7.5 then?
If we could,
Okay, we'll move to
please.
7.5 Crown grazing lease minimum tax.
Perfect.
So, for this item has had numerous discussions to date. The last motion from council was to bring this item to our Tax and Finance Committee meeting. The Tax and Finance Committee reviewed it, discussed it. They still had some questions, but overall the motions that have come forward are for us to continue with a minimum tax. The question that that still needs to be determined is how Crown grazing leases are linked to the minimum tax. Currently, the process is each grazing lease receives its own individual tax notice and is also eligible for the minimum tax rate per parcel. Even if the lease contains multiple parcels, they are subject to the costs of each individual parcel on that. The discussion previously at the committee and council level was, is this equitable, is this fair? The opinion of administration is that while there are concerns that you have multiple pieces of property, we look at it as the capacity of those properties to get resources to market require increased resource commitments to the county. We did the analysis. Currently, the direction for a minimum tax was to look at a phased-in approach with the minimum tax going to $100 this year and potentially up to $150 the year after. And we've provided a financial analysis to show that if you were to change the structure so that leases were grouped, it would be approximately $103,000 in revenue that municipality. The thought process too is when we've done our census data and our high-level surveys information, it is clear from the public perspective that the priority of emergency services and some of our services within the county are needing to be enhanced, and there's support from the public based on those surveys to enhance that. But that said, they come with a significant cost. And we look at things like a fire truck as an example. When a fire truck is increased in replacement costs over $1 million in the last 4 years, that revenue has to be deemed from somewhere. And it's important to note that we only received 2 formal complaints about the minimum tax changes. Yes, there were people at the counter that were that provided comments to our staff saying, oh, it was a shock that my tax bill went from $1 to the $50 or things along those lines. But ultimately, we only received 2 formal complaints. And our opinion is that we should tax these individuals based on the parcels, not on the grazing leases. That said, there were some additional questions and comments that I know some of you had, so we thought it would just be best to bring Troy, our assessor, to answer those questions on assessment and calculations just to increase clarity. The other reason we're bringing it to the GMP is simply because our next tax and assessment committee meeting isn't really scheduled until April. And with our budget trying to be finalized, we just wanted to make some additional progress on those discussions with council. So we had a better idea where it was going into the new year.
Hey, up to council for discussion. Councilor McNeil.
I'll dive in. So, there's a few things. So in the RFD, there's some information that I don't see that I would have liked to have had. For example, the breakdown, it doesn't include what was paid in 2024 and the grouping, how grouping would affect that revenue. So like on the one hand, when we talk about revenue loss by grouping over implementation, 100,000, I don't really see that it's that 103,000 is that 103,000 more than what it was in 2024, for example. So I don't know that it's lost revenue because it hasn't been realized revenue yet. And to kind of speak itself to the motion, I've had a number of calls about this, and I fully suspect you'll have more people that already, we have 2 emails just in the hour before our meeting from 2 residents, about this. So I expect that there'll be more formal complaints. Part of the comments that I heard was that they didn't know about it. They didn't know about it in advance until they got their bill or didn't really notice the difference. And when it comes to a minimum tax on a parcel, I'm not concerned about that. That obviously makes sense. But in the example in this RFD the example is for the parcels, the person in 2024 was paying $1,000. Now, go based on this current framework, in 2027, they're gonna be paying $7,000. So that's a 700% increase in their taxes, which then goes to 2 questions. I mean, ultimately, we have 2 questions. One is, what taxation rate is fair based on the others? And then I think in the context of this, what is reasonable? So the taxation question about what is fair, I almost think that's a different discussion for a different day. If we're gonna be evaluating fair taxation across all tax levels from an assessment purpose, that makes sense. But is it reasonable for us to be increasing 700% over 3 years? And also the question that I had is, how many title owners does this apply to? So we've been given the data on, it's in the RFD here, I can reference it, about the number of properties, et cetera. But I mean, are we trying to make this $100,000 off the backs of 20 title holders, is my question. And if that's the case, is that how we want to be addressing our rural properties? So those are some of the concerns I have. And I guess to wrap it up, I would really like to see this move to a public engagement session and open it up to the public and be able to get more engagement or more information, at least with the affected title holders. Thanks.
Mr. Ferris.
I just provide a couple points of additional clarity for council. So I may be off by a year or so, but the rates for farmland are based on regulations from 1985. Those rates have not changed in that 40 years. that is how the assessed value of agricultural land has been assessed across the board. It's based on various criteria of soil quality, tree cover, that sort of thing, but those values haven't ever changed. So while you look at a minimum tax as an implementation tool, it is a way to address the fact that a residential property, a commercial property is assessed at market. The regulations from the provincial government say that farmland is assessed at 1985 rates. I don't think anyone in this room would refuse purchasing a farm parcel at 1985 rates based on the actual market value. So taxation is supposed to be an equitable mechanism, and while yes, an increase over a couple years is concerning, you may also say, I believe it's 40+% the residential tax rate has went up over the last decade here in this. That did not happen to agricultural properties at all, because there was no minimum tax. And a great example would be there's a line item in the package, I think it's page 133. There's a 12.9 acre parcel. And now this is for a lease, but if this land was also privately owned, it would be very different. But that person, that individual, paid 96 cents in municipal taxes in relation to, if that was a 12.9 residential parcel, that would be market value, and it would be significantly more than the 96 cents for that parcel. So there is that mechanism where those regulations have come into effect, and the thought process administratively as well is there is not, I can't say that, there is not. It is very difficult for the ratepayer within this county to say they do not get $50 worth of municipal services from this county. That doesn't even cover the gas to cover the grader or the plow to go in front of their property, which is $500,000 to $1 million, plus the qualified person inside of it. On top of that, the fact of an equitable coverage of if there's a fire on one of these farm properties or one of these leases, you need that $1.5 million fire truck with the trained crew to show up to it as well. And so while percentage-wise it is significant, I would argue that a $50 minimum tax or even a $100 minimum tax, if it was to continue going on there, is still underserved in relation to what our other taxpayer groups pay. But yeah, I just needed to clarify that the 1985 rates in terms of what the difference were in 2024, for example, for the municipal portion on a 12.9 acre agricultural parcel, they paid 96 cents. And in 25, they paid $50 for the municipal portion. So yes, that is a significant increase, but from a service level point of view, the thing that we heard, or what I heard when I was working out of the fort and people would come in and provide that concern is it's still reasonable, and we were sending out tax bills that weren't even covered by the cost of the stamps that were going on the paper. So there are those aspects of it too to consider as well.
Councillor Coogan?
Yeah, first of all, I guess I would suggest that there's a huge debate in the difference between owned land and leased land, which we haven't addressed yet. And then there's the other portion of it, which I did some research into the administration of public lands and the regulation. And section 62 of that specifically makes it really difficult for me to support a sort of a unilateral coverage. And that is that if, let's say in a green zone, grazing lease is harvested by an FMA holder. Well, the administrator can say, first of all, that, okay, now that property, you can't use it for 3 years. But the leaseholder, in order to maintain the lease, will still have to pay the taxes on it. So these are some of the fundamental questions that we haven't answered yet. And I think it serves a purpose for us to do a public engagement and have both what CAO Ferris is saying and what we're saying on the table that says, look, there's an argument for you know, the grader going down the road in the fire service, but there's also an argument for fairness. I think that we can't compare them as being the same because they're not.
For me, I personally believe that it should be looked at as a parcel to a parcel to a parcel. I mean, I understand it's a lease parcel versus an owned parcel, but on the other hand, if you have somebody, you wanna be cognizant and be careful because you feel that we're taxing somebody too much because they're leasing the property, they're still generating revenue off of it, they're still utilizing it. We still have municipal infrastructure to get to it that we have to pay for, and we wanna subsidize their rate instead of somebody who has to pay for, just because they own the property. I don't feel that that's also fair across, if we wanna look at agriculture, why should somebody have a lower rate and a subsidized rate just because they're leasing the land that, again, that they're tied into, I understand they're tied into a multi-year, usually agreement with the province on. Yes, there are, things that can happen to that land, but if you own your property, you also run the risk of something happening where your land becomes infertile and you can't use it. You're still paying taxes on it. If you have a really bad drought season, you have very limited resource off it. You still have to pay taxes on it. Why should one be different because it's owned versus it's leased? You're still utilizing the land for your operation. It's still a part of your revenue stream. It's still something that you require to be able to get there. We still have to municipally serve it. So to me, it should be treated as a parcel and a parcel and a parcel. Mr. Orwa?
Yes, through the CEO to the chair, I just wanted to request Troy to weigh in and see if you can also help clarify because you're always in the field and looking at this.
Yeah, thank you. As we're all aware, the farmland assessment, as noted by CAO, is a regulated assessment, so when we're referring to these grazing leases, they're generally parcels in remote areas of the municipality that are covered in trees that have poor ag capabilities. And that's why, from a farmland perspective, the assessment of them is quite low. With that said, right across the road, you could have a cleared quarter of land, cultivated, growing wheat and barley. The assessment is still low in relation to market value, but it is higher and would probably hit that minimum tax threshold that you spoke about. I certainly prefer to stay out of the tax debate, intentionally. But I'm the assessor for many rural municipalities, and some do it one way and some do it the way the county is here. I don't know from a tax perspective, when you look at it from a percentage increase, 7,000 or 700% increase, you think about that, that's crazy. But it's still way less than if that parcel was not farmed. Go further to that, so you have the grazing lease quarter across the road, you have the titled farmland that grows wheat, and then beside that you have a bush quarter that has nothing to do with farming. So you've got an assessment of 5,000, assessment of 15,000, an assessment of 150,000+. So taxes are, $20, $40, and $500. Virtually all the same kind of land, like quarters of land. So taxation with regards to farmland assessment has always had, assessment of farmland has always had tax policy built into it since, like CEO first said, since the 80s. And the reason why, I suspect, is because back then and continued through time, the political decision makers decided that it's best. We all need agriculture, obviously. I don't think anybody wants to argue that, and that's why the tax policy is built into it. But from an assessment perspective, I've seen it in both ways. We do it. We have a grazing lease master where 10 parcels, the total assessment is added up onto a new roll, and that's the taxable roll, and if that's below the minimum threshold, then they pay the minimum tax. And I have other clients where each individual assessment, just like in the county today, would
if it's below the minimum threshold. There's no one way that's right or wrong.
Councillor Dean and Councillor McNeil.
Through the chair to administration and to council, a couple things I wanted to bring to light, if you will. First of all, the example of the privately held land versus the grazing lease, they aren't the same with respect to what that grazing leaseholder is entitled to do with that land. For example, you have a privately held quarter section that's fully treed. If you've got a market for it, you can harvest those trees. You can't on a grazing lease. The province comes in and tells you what you can do, even to the extent if you want to build a fence, how much you're allowed to clear, etc. The province also dictates animal units, so how that land can be utilized. So the restrictions on a lease are substantial compared to privately held land. And then the other thing I wanted to add, especially for the new councillors here, is some context as to how this came before us. And I appreciate the fact that we're having this discussion. And I also would support some public engagement on this. When the concept of a minimum tax was presented to council in the spring, council wasn't aware of the implications to the grazing leaseholders. And I think if council had been aware of that, then this type of discussion would have taken place. So just so that people understand that. But yeah, I would support a further review and public engagement on this.
Councillor McNeil.
Through the chair to Mr. Brittles, I just wanted to clarify. So you mentioned a bush section. So if there's a leased bush section, do we have a tax assessment on that?
Yes.
Okay, so then how, you said the assessment then, for example, like on a logging or like on a lease section is considerably higher than what it is on a grazing lease?
On a leased parcel is generally lower than on a cultivated parcel of land.
Right.
Think of it based on your ability to generate income via agriculture. You're not gonna run a cultivator through a bush quarter, you can't grow wheat. So really all you can do is graze cattle and you're limited by whatever the province allows you to. But if you own that land, and if it's still just bush, the assessments will virtually be the same.
I guess to clarify what I was meaning is currently in the county, wherever we have in our forest protection area, so we have these sections that are not grazing leases, that are not county owned or privately owned land, they're crown land. So we don't currently collect any assessment for those properties.
No, that's correct. There's no.
Okay, so then I guess to kind of go again, and what I heard with the conversation around the table is kind of what I led with. There's two fundamental questions, what's fair and what's reasonable. And I think those are two separate questions for the context of the people, that we're dealing with this question and potential public engagement could address both questions. What's fair and what's the path to maybe fair taxation if that's the case? And then what's reasonable? What's the reasonable path to get to that point? And based on the information that we've been provided, I definitely wouldn't be able to support most certainly increasing the tax to $100 like what's been here. I certainly support the idea of a basic, fee for one parcel if you only own one parcel. But that's why when I was asking how many title holders do we have, what's the grouping? And when I went back, I had to actually go back into the meeting package from the taxation committee meeting August 5th. It wasn't included in here. And Reeve Cush had made the motion coming out of that meeting for administration to bring forward a grouping discussion and budgetary implications to council. So with that, I don't really see that information in this package. So that's kind of, I guess, where I'd be going with that.
Or the discussion with council around the time was having a $50, if you had 6 leased lots, having that as $50 total for 6 leased lots. And when I look at that, it's, okay, so if a person has 6 leases and we're gonna give them, cause it's on one tax notice, a $50 minimum and that's their bill for 6 leases, what are we gonna do for people that own 6 parcels? We don't do that for them. And again, when it comes down to equity and being fair, why, treat one group differently than the other because they had to put more capital into purchasing their property than somebody who has it leased? Councillor St. Martin?
Mr. Reeve through to CAO Ferris. So my understanding of minimum tax is that it can't be discriminatory, so it's applied across the board to all properties. Unfortunately, in this case, it's picked up these grazing leases. I have talked to a couple grazing lease holders. Of course, they don't have the multi-parcel, they do have 5, 6, 7 leases. Their comments to me were, so for example, the province has increased the application for grazing leases from $50 to $1,500. And that's been over a period of the 1980s to now. So there's been a huge increase in those application fees by the province. It was also mentioned to me that, some of these leases do have oil and gas facilities on them, and those grazing leaseholders get revenue from that, which offsets, some of them do, not all. I'm trying to be solution-based, so I was thinking about maybe we have a seniors tax rebate, we have a veterinary service program, we have a pesticide program. Like maybe there's some type of rebate that would be for all properties, not just grazing lease, if threshold. So if there's 10 or more, you're entitled to this rebate, or if there's 20 or more, you're entitled to that rebate. So that might be an option, I don't know, for council to consider, or maybe administration can look into that. The other comment was that if a farmer is renting private property and they're putting animal units on that property, the rate for the per animal unit is considerably higher than what it would be on a grazing lease. So that's another factor. I would support public engagement, and thank you.
Councillor McNeil?
I'm prepared to make a motion that council direct administration to, is it to go to council for a decision on public engagement? Or can that decision be made here as a point of order, I guess?
Mr. Ferris?
Technically, yeah, this is an advisory committee, so I'd recommend that you bring it to council to ask administration to come up with some type of community engagement plan.
Okay, so thank you for that. So just to revise then, prepared to make a motion that the committee make the recommendation to council to advise administration to bring this forward into a public engagement session.
Discussion on that motion? Call the question, all in favor? I would like to make a second motion on this, given where we are in our budget cycle, that the committee recommend to council to continue with the $50 minimum for 2026 and not continue the phased plan until further discussions. Councillor Dean?
Speaking to the motion, when this topic was brought forward to council, after council had accepted administration's recommendation to go forward with the $50, we had considerable debate on it, and at one point we'd even considered withdrawing that. And from a mechanical point of view, it was going to create problems with our financial department because the tax notices had already gone out. So the concept that had been tossed around was that the landowners would, and the grazing lease owners would pay the $50 but there was potential that they would have a credit applied to their 26 tax notice. So I wouldn't be in support of going forward with a $50 minimum in 26, given the fact that council's on record as considering rebating that tax that had already been applied.
For clarification, there was a discussion that if we decided not to go ahead with the minimum tax rates, that they could, because the policy came in 1 year and then came back out, that they could possibly look into that, but it wasn't an official motion or movement from council that we were going to deny or credit. So with that, there is a motion on the floor. Any further discussion to the motion? Not seeing any. Motion to move to council for consideration. Call the question. All in favor? Opposed? So it's carried. We'll come to council again for another discussion. Thank you very much for your time, Mr. Biddle.
You're welcome, anytime you need me, just let me know.
No worries, it's been an hour and a half. We have a couple items left. Need to take a 10-minute break, or we wanna keep going?
5 minutes.
Okay, if you wanna just take us offline there, we'll go off here.
just letting you know that they're not.
Okay, 6:35, we're back, we'll start 7.3, policy IS 6402, fleet life cycle management policy again.
Thank you, brief question. So as part of our ongoing review of our life cycle in relation to our asset management and also a tangible capital asset discussion we're having, particularly in how it relates to our municipal indicators that in the past we haven't hit every year in relation to our capital investments. We wanted to review our equipment life cycle plan, not only for the implementation of our citywide asset management program, but in relation to TCAs. And then we also wanted to look at it from the perspective of not only condition assessment, but recognizing the realities of these capital costs and how they relate to our budgets as well. Administratively, we do struggle to recognize that our old policy, for example, with pickup trucks had a 10-year life cycle and a 200,000 kilometer limit. But we're also have the realization that we have our ratepayers that are driving vehicles sometimes over 200, quite often over 200,000 kilometers and potentially older in years. We do think we can extend the life of some of our graders because of our great mechanics and processes we've implemented. And so we did a review, we did a comparison of the numbers that other municipalities were doing, like Lac La Biche and other municipalities that have moved along further. We also did a review in relation to how some of this relates to fire apparatuses as well, because in the last couple of years, as I mentioned, it's now routine for a frontline fire truck to be over $1.5 million. And while there are standards available for like the national firefighting standards, those are guidelines. They aren't mandatory. And we are of the opinion, based on the equipment that we have, we can extend some of its life. And there was a report that was done that all municipalities are falling into the upper range of fleet timelines and replacements and those capital costs. And so we wanted to do this review, and we reviewed the MD at Greenview, Lac La Biche. We looked at our current policy. We also looked at how we could change it and make some tweaks. And we're of the opinion that with this plan, it should extend the life of most of our equipment. By no means does it preclude us from needing to, from needing to replace a vehicle before then if we're running into condition areas or deterioration. It's a sad fact is not all equipment goes the same length of time as it would previously. But we wanted to ensure that the level of use and the type of use and its reliability, and then also when we factor in the cost of maintenance, repair, as well as its integrity are factored in, but while keeping some high level benchmarks as well. So before you is a draft policy to replace that, along with a respective draft procedure to get council out of the weeds of, so to speak, recognizing that setting those benchmarks at a policy level are problematic, and procedurally it's probably better to separate that into a procedure to better indicate the level of use, types of use, reliability factors, and that sort of thing for our staff to manage it. Happy to take comments, feedback on it, but in general, we do think it's a step in the right direction. It does show that our equipment we hope to make last longer than some of our comparables, and I think that's a good thing for the taxpayers of this community.
Thank you, Mr. Ferris. Any discussion from council? Councilor Kuchen?
Yeah, through the chair to CAO Affairs. First of all, I'd like to say whoever did this is a long time coming. Personally, you guys must have had a farmer on your staff. I've got a tractor that's got 27,000 hours on it. It starts every day. It does the same job that a new one would do. So I really believe that this is a really good change. And I do understand that, you know, you will have to monitor and reevaluate if there's a piece of equipment that just doesn't meet that. That I fully understand it, but I think you're on the right track. And there wasn't a lot here that I could be critical of.
Thank you. Anything else, Councilor McNeil?
So I just had a few points on this one, through the chair to CAO Ferris. One is, there's a couple of things, so the vehicle colors and the decaling doesn't appear to be addressed in the new policy or procedure. So that's something, just when we're bringing forward and getting rid of a previous policy, if we had strike-throughs or something to bring forward, just so that, you know, it's noted. And if this is addressed in a different policy somewhere else, then that's great, but it just appears that it could be a thing. So for example, the old policy states that all our vehicles are bright white. You know, decaling is set out in those policies, which is pretty typical in your purchasing policy, that you'll find standardized. Also, it has the lead, about the involvement of the lead mechanic and the fleet team. And I was wondering if the lead mechanic and the fleet team were involved in the development of this particular policy, if they've reviewed it before we have.
The chair, the lead mechanic has provided comments. The entire fleet team I can't speak to. I would assume there was a collaboration mechanism there. But fleet has been involved in the production of this and even within some of the trial assessments that we've done.
Awesome. And then just the other two are just quick little edits. So on on our package, it's page 103 and it's 2.2. Bear with me when I get to that page again. Okay, so in that one, under 2.2 maintenance, it says major expenditures may not, and now I lost it, but anyway, may not, and then it goes in to describe what it may. I would recommend changing the may to should. I agree with the intent of it, but what happens is that if we run into a case where we can't get chips for vehicles or some other part, then this will give you the flexibility to make that administrative choice, so you may want, in case that you want to. So that was, and then the last one was page 106. And if I see it here, bear with me. And it was literally just under point number 1, draw on his own experience. I would just modernize it, change his to there. And yeah, I think outside of just the catching the colors and the decals to make sure not losing something from a previous policy.
Mr. Ferris?
Just to expand on those two removals, I am of the opinion that operationally, the color of our fleet and how the decals are not council policy. And further, we will be implementing some procedures to address that, particularly in relation to the white vehicles. I am of my personal opinion is we want to get the best vehicle we can with the lowest price. And if there is a red truck that is cheaper than a white truck, I would prefer organizationally we're not restricted. Aesthetically, it is nice. But a truck, regardless if it's neon pink, will still do the job as a white truck. And so I would like to, procedurally, when this goes forward for implementation, we will absolutely have procedures to address the logos. We also have some procedures currently in relation to logo usage and how they have to be applied anyway. I would probably say I'm reluctant to completely restrict vehicle color, just in the event that even with, we continue to experience supply chain issues even to this day, and wanting to have to wait just because a truck needs to be white, I think reduces our service level as an organization. So I would caution that if that was a direction of council.
Else from council? Not seeing any. Councilor St. Martin?
I'm prepared to make the first motion.
Okay.
that the committee recommend that council rescinds policy 3106 vehicle and equipment maintenance and replacement.
Just point of clarity, I believe those recommendations on the RFD are for the council level. Because at the committee level, we can't rescind the policy. There are two, under the 7.3 on the side, there's two different recommendations.
I changed the motion to reflect that the committee recommend that council.
Thank you. Motion on the floor? Discussion? Seeing any, I'll call the question. All in favor? We have a second. Councillor Coogan?
I'll make a motion that council adopt policy or that
The committee recommended.
committee recommends that council adopt policy IS 1-6 402 fleet's life cycle management policy as presented, and further supports the fleet cycle management procedure for immediate implementation by administration.
Thank you, Councillor. And if I could make a friendly amendment to bring back the policy with council amendments. There was a couple clerical amendments that were mentioned there.
I will accept that as a friendly amendment.
Thank you. Discussion to the policy or the motion? Not seeing any, I'll call the question. All in favor? It's moved. 7.4, policy G1009, council inquiry policy.
Thank you, Reeve Cush. This was our first kick at the can, in relation to the discussion we had previously, where the thought process of having some level of structure, in terms of inquiries from council and how they would be addressed. We looked at Grand Prairie's policy, we looked at the County of Wetaskiwin's, because those were ones we could readily find on the internet. Tried to streamline it to what we think would work. I will say that after almost 2 months now of after the election, I think we're finding our groove that way in terms of communication responsibilities and response times. But I do think there's merit to not only hold myself and staff accountable, but to make sure that those expectations are clear. The way I look at it is the mechanisms within this policy are the guideline. I don't want it to be construed that this is now the response time or expectation that council solely has. I think in a lot of cases our response times can be better than the policy, but this sets the minimum standard for that. And if we need to change those minimum standards, I'm happy to it. I think many of these questions, and I think from a response time from our team, I think council has regularly gotten the responses well before the 2-day window, probably even the same day to the same expectation. But I do think just having this so that our staff realize that council would like the information or get these requests, but they can breathe and do their other work beyond the individual requests, will help support our staff to ensure that they give you the information that you desire, but also so that we can be held accountable by writing it down. I'm happy to take feedback, change, as I fully recognize this is the very first draft of this, and we may need to have further discussions on it.
Thank you, Mr. Ferris. Discussion from council. Councillor Dean.
Just kind of a general housekeeping question that, you know, as, sorry, through the chair to council and administration. As CEO Ferris mentioned, you know, this is our first look, and policies can always be amended. So if we find that it's too onerous or it's got holes, we can always amend it.
Council. Anything else, council? Councillor McNeil.
A few comments. So definitely one is kind of related to the service tracker. So, and absolutely, I think we should be encouraging the public to use the service tracker. But I also wanna make sure, like, we have residents that don't have a computer, don't have a cell phone, you know, still only operate on house phone. And they're gonna pick up the phone in a lot of cases and they're gonna call their counselor. And their expectation is that the counselor is then gonna act on their behalf for a service issue. So I do understand that the proper process is for that counselor then to create the service tracker issue on their behalf or direct them to phone the office. But in most cases, our residents are looking for counselors to do something for them. So with that kind of in mind, then it would be my expectation, if I'm the author of that on behalf of a resident, that I be updated on that particular service item in the same manner and in the same space as any other resident. You know, I certainly wouldn't expect as a counselor that, you know, I get prioritized, I wouldn't expect it or want it, but I definitely would want that feedback. And the way that this policy is currently written is that there wouldn't be feedback provided on these requests to counselors. And that's something that I would like to see changed. And then also, section 1.3, service standards should be defined. An acknowledgement of a request with an anticipated follow-up of a date of response is likely reasonable. And I just found that was a little bit ambiguous. I kind of like that section, it kind of needs to read like levels of service standards, not wishes. Because when it says like the county will endeavor to acknowledge inquiries, that most organizations have a standard of service, you know, and that's what's kind of listed. So that then down below, you know, and one of the things that was brought up in this example, you know, was about routing and examples. And I was guilty of one of the examples, which was I had a resident who had mentioned that their sign had been flagged. And so there was a survey ribbon put on their home address sign. So what I had done was I had reached out and emailed all of council and to the CAO through to, and I think had maybe CC Jeff on it, I'm not sure. So, but my question was, were there crews working in the area that may have put this on? Maybe they were flagging a ditch or a culvert, I have no idea. And the reason that the resident was so concerned is because there has been cases of people using this kind of marking to steal dogs, break into homes, stuff like that. And in the past, for example, when we had flooding, then the Public Works Department, when we were on evacuation order, that's how they noted the homes. They came along and tied these ribbons on the homes that there were still people in. So it had been a practice that was in use by the county in the past. So when she brought the issue forward, I, at the time, thought, you know what, this is a quick and easy answer. I did not expect to get an answer to my email right away, you know, but I expected it would be, somebody say, would pull the address, they'd look, no, we didn't have any workers in the area that last week, perfect, like a 10-minute thing. I didn't expect it was gonna be like an in-depth issue. And then it was a week later that I reached out and asked, have we heard anything on this? And then when I look at this policy, I basically see like 3 areas where that's referenced as a do not. So my question through to the chair and to council and administration is, okay, so now I would fill out a service tracker request instead of emailing and asking this, which I can see is that's the proper, but then I would expect that service tracker response to come back to me as the author of that response. So I guess that's kind of the discussion that I'm concerned about with some of this kind of stuff.
I can speak as somebody who's put requests in for residents on Service Tracker. There is a part where you can request a follow-up, and I've always had follow-up when a request has been done. So I've never not had that when I put something through.
Okay.
Councillor St. Martin?
Mr. Reeve through to CAO Ferris. When I read this, I would like it defined when we're on a committee, and if you're a chair of a committee and you need information added to the agenda or delegation or something of that matter, how is that gonna be handled? Because I don't think that's something that needs to go through council.
Yeah, just for clarity, I think the goal here is not agenda item additions, not to change structures for committees. It's just, sorry for using the example of the ribbon within the policy, it was just
It was recent.
it was fitting as we drafted it. That one, as my staff have indicated to you, those requests to ensure we're giving you the whole picture and not a quick 10-minute check, because there's a lot of moving pieces within the operation, whether it be contractors, third-party line people, that sort of thing. We wanna be as thorough as we can, and that verification that perhaps that person missed that ribbon in the last couple of weeks, right? There's always that possibility, and our preference is to provide council with the whole picture rather than just pieces of it, so that you're advising the public once rather than multiple follow-up pieces. And so the intent there was, if we can track some of that in Action Tracker and just have it go through those workflows where it goes to the right person, that's great. Those type of requests, losing my train of thought here. So the examples are there because they were really good examples where it's a basic request. The time needed for some of those operationally are more detail written, and we just wanna make sure you get it. So that's why we're trying to aim those requests to the tracker. For committee council, my personal opinion is this policy is not meant as a way to restrict items to go to any of those. We can absolutely put some clarity within this policy to say this does not include additional items to council's committees or information to supplement an agenda item.
Councillor Dean?
Through the chair to admin and council, once again, I just wanna reiterate the point that this is a draft. If it's not serving our needs, we can change it.
Okay, anything else from council, or do we wanna move this to council with, I guess, a few amendments here, it sounds like? Councillor Dean?
Sure, so I'd move that the GMP committee recommend to council to approve policy G-1.009 dash council inquiry response with the discussion items as discussed.
Thank you. Discussion on the motion? Not seeing any. I'll call the question. All in favor? So moved. So before we get to 7.6, I need a motion to go into closed session under the Freedom of Information 17, 19, 23, 24. Councillor St. Martin?
I can make that motion. I need to restate it.
We're probably good. Call the question to go into closed session. All in favor? It's carried. We'll make sure that we're not